Taoiseach, first of all, I want to welcome the decision of the Irish people to support the children's referendum last week and to insert the proposed clause into the Constitution. But that decision was stained somewhat by the very stark and blunt judgment of the Supreme Court when it essentially made it very, very clear that the government not only dismissed the McKenna judgment but were in breach of the Constitution in carrying out its own promotional campaign in relation to the amendment itself. The Supreme Court was very, very clear that there was a misstatement contained in the material produced by the government, as well as, and I quote, as extensive passages in the booklet and on the website that do not conform to the McKenna judgment, unquote. It was held, the Supreme Court said, that the government in expending public monies in the promotion of a particular result in a referendum process was in breach of the Constitution, and that the government had acted wrongfully in expending or arranging to expend public monies on the website, on the booklet and advertisements in relation to the referendum on the 31st Amendment of the Constitution Bill 2012. Now, Taoiseach, for some reason the government obviously decided to formulate its own information and advocacy campaign parallel to the information campaign of the Referendum Commission, presumably for its own political purposes, to use some of the taxpayers' money to advance its own situation. Or some have argued, and this is despite the fact that Judge Kevin Feeney, following his report on the referendum campaign on the fiscal treaty, when he said that research found that dual campaigns cause problems and confusion. Now, you had that report for quite some time, took a long time to release it, and that should have really given you a warning sign not to go down the route that you subsequently decided. And in essence, what seems to have happened is that the Referendum Commission had its money pulled back. The government took a tranche of that money and used it to produce its own materials. Or others are suggesting maybe that because the government was annoyed at the work of Judge McMahon in relation to the Oireachtas public inquiries referendum,
question, please. Thank you.
that they decided that we have to run our own campaign, that we cannot trust the Referendum Commission anymore. Did someone say something?
No, please, we're over time. Don't mind.
In relation to
Thank you.
So I just wanted to ask the Taoiseach some questions on this. Obviously, the Minister Fitzgerald took a calculated decision to actually proceed on this route of an independent government campaign separate to the Referendum Commission. Can you outline why that decision was taken, Taoiseach? And secondly, did the Attorney-General examine all of the information that was contained in the booklet and on the website prior to circulation?
Thank you.
Because Ministers Radcar and Minister Fitzgerald have clearly said they kind of laid the blame on the AG, and Deputy Brian Walsh of Fine Gael went very far this morning when he said that if she played an active role as the AG in the final sign-off, then she would have to consider her position. Now, I think this needs, if government deputies are saying this needs, I think, a response, Taoiseach, from yourself in terms of what was the origin and the sequence of events that led to this situation.
Taoiseach.
Well, firstly, Cancora, may I say that I'm very happy that the people made a very clear decision in endorsing the referendum proposal to give children recognition and protection in the People's Constitution, Bunrath na hÉireann. It's also false to me, I think, to say to all the parties in the House here that I thank them for their contribution to the campaign. I thank the advocacy groups who spoke out and who campaigned for this, and most importantly to the people who actually went out and voted, and clearly and specifically those who gave a clear majority verdict in respect of this. Now, Deputy Martin, I might say to you that the first thing is that the McKenna judgment has been around for over 17 years, with a second judgment back in 1995, or a second appraisal in 1995. Actually, no court has ever set out specifically what the parameters and the confines and the meaning of the McKenna judgment actually were and are. And I would say this, that the government, insofar as putting this question to the people who are concerned, following a call over 20 years ago by Judge Catherine McGuinness that the Constitution be amended. We've had all the different attempts over the years, and inside 18 months now we've had 4 questions put to the people, including this one, which has been endorsed. I might say to you, Deputy Martin, what government set out to do here was to uphold the principles that apply in this, and Minister Fitzgerald followed a very clear line in dealing with the requirement to have information given to people, to deal with misinformation, After all, there were groups saying that forced vaccination would be put on children, compulsory vaccination, that the state might step in and prevent parents from bringing their children to mass if that's what they wish to do, or if that was their wish. But a great deal of misinformation going around about this matter. Now, Deputy Martin is also aware that the High Court gave a very clear verdict and judgment, in an 11-page judgment, in respect of the website, the advertising, the booklets, about that background, about that information, and about what the government were doing. Clearly, on the 8th day, when the Supreme Court made its decision, government responded immediately to that in fully accepting the decision of the Supreme Court and enacting accordingly immediately. Now, I think, Deputy Martin, that it's very important that we do not prejudice or comment unduly on the reasons why the Supreme Court gave their judgment in the way they did. What they have done is to produce a preliminary conclusion here and a preliminary judgment. I think it's very important for you and for everybody else to await the detail which will be outlined in the Supreme Court judgment in December, and that this House reflect on that, taking into account the background to this, the whole McKenna judgment, the question for future referenda, and what it is that has an oireachtas in respect of the People's Constitution, Bunrath and Heron, what we should do for future.
Thank you.
The bottom line here is that the people have changed the Constitution. They've gone out and voted in a clear majority to give children protection and recognition in our Constitution, and government will now move on to introduce the necessary supplementary legislation to give effect to that and to change forever the nature of the way that children were not treated in this country. And this amendment is for the benefit of society and for children in particular, those in vulnerable situations and those in the limbo land of foster parenthood, where there is no prospect for a minority of them of being able to have adoption brought about. So in that sense, I want to wait until I see the detail of the Supreme Court's analysis, and they're entitled to that without deference or speculation, idle or otherwise, about the reasons why they gave their judgment in the nature and the way that they did.
Thank you. Deputy Martin.
Taoiseach, there's no speculation. There's no one adding any reasons. It's just what's factually said by the Supreme Court itself, that you were wrong, that you were in breach of the Constitution. Do you not get that? I mean, we don't have to wait for a month. This is the decision of the Supreme Court. And I am somewhat concerned by the equivocal response of some of your ministers, particularly Minister Shatter, first off, when he said, you know, the suggestion being, of course, by innuendo, that the High Court is nearly as good as the Supreme Court. And sure, the High Court said one thing, and sure, the Supreme Court said another thing, and we're very reasonable people in the middle. Now, we in Fianna Fáil wouldn't have the same intellect as Minister Shatter by any means to put themselves in the same place of the Supreme Court, nor would we ever attempt. Nor would we ever attempt to second-guess the Supreme Court. That's a matter for members of Fine Gael who are either in the law library or who are in government. But could I say this to you, Taoiseach? I think, Taoiseach, every now and again a bit of contrition would do no harm. And I think when the Constitution is broken by a government, it's a very serious and substantive issue. And it's a very profound issue, Taoiseach. Because people were annoyed, Taoiseach, before the poll. This is the more serious aspect of it. Why do we have to risk the referendum by something that wasn't necessary at all?
Thank you, Deputy.
Because the referendum commission system is actually working, and it has worked in previous referenda, despite the government's annoyance with the oireachtas inquiry, which I don't think was justified at all. But by and large, it has worked, Taoiseach. And people trust the referendum commission. They trust the independent judges who chair it in terms of imparting objective material. And could we not resolve from now on, once and for all, governments in the future, do not get involved in that final phase of the campaign in terms of trying to advocate a position using taxpayers' money. The McKenna judgment has made it very clear. The Supreme Court has said you were wrong. I think you should say sorry to the people that you got this one wrong, and make sure that in future there is one straightforward, objective information campaign that is the one put forward by the Referendum Commission, not by governments. Up to political parties to argue the toss between themselves, and those for and against the debate to argue the situation in a normal debate.
You made two comments in your original question also, Deputy Martin. You said that for political purposes, a political agenda, that Minister Fitzgerald was following a particular line here, and you also said that perhaps it was because of something to do with Judge McMahon and the way he had handled a previous matter. That is absolutely irrelevant, as there was no such political agenda and nothing to do with Justice McMahon involved in this. As I said, in good faith and in wishing to uphold the principles that apply here, clearly survey after survey shows that people wanted more information, they wanted further information. I listened to all the vox pops, I listened to the avalanche of cynicism about this. The fundamental issue here is that a clear majority of people went out and took the time to go out and vote clearly for the referendum, which changes the way and the treatment of children for future. As I've said, it's been going on now for 20 years, and inside 18 months, government put the question and it's been answered very clearly. I think it's far more important than you're giving due weight to, Deputy Martin, to wait for the final comprehensive reasons, the full judgment of the Supreme Court. What you have there is their preliminary judgment. They didn't actually spell out, for instance, the paragraphs that they referred to in the Supreme Court. So I think it's absolutely critical. I think it's absolutely critical, Deputy Martin, that we do not interfere with the reasons why the Supreme Court made their decision in the way they did, and the reasons for making that decision. We should show them due deference to allow them to produce their comprehensive, detailed judgment for publication early in December, and I wait that with interest. You are judging it there. This, as I said, a great deal of misinformation was about here. For instance, we're looking at the Limerick leaflet which went round. Now is not the time for property taxes, and why we are supporting the children's referendum. These things cause confusion in people's minds. So we move on from this. The judgment is very clear. Children have a new status of recognition and responsibility in the Constitution, and we move on from that.